In this video, I'll explain why your Florida single-member LLC may be offering you zero asset protection and what you need to do to fix it right now. And by the end of this video, you will learn exactly why Florida courts treat single-member LLCs differently from multi-member LLCs and why that difference can cost you everything you own, and the specific steps you can take today to close that gap and actually protect your assets. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I spent nearly 3 decades structuring businesses for entrepreneurs, investors, and high-net-worth individuals, and the single biggest mistake I see is people who think forming an LLC is enough. It's not. And in Florida, that mistake is especially dangerous. All right, let's dive in. Here's what most business owners believe when they form an LLC. They believe that if someone sues them personally, their business assets are protected. And they also believe that if someone sues their business, their personal assets are protected. That sounds right, but here's the thing. In Florida, if you own a single-member LLC, that second layer of protection may not exist at all. And right now, you're probably thinking, wait, I was told my LLC protects me, and it does to a degree, but there is a very specific vulnerability that most attorneys don't explain clearly at the formation stage, and it has a name. I call it the charging order gap. Here's what that means. In Florida, when a creditor wins a judgment against you personally, they have legal tools they can use to come after your business interests. For a multi-member LLC, Florida law limits the creditor to what's called a charging order. A charging order is relatively weak. The creditor has to wait and hope that your LLC distributes money to you, and they only get paid if and when that happens. They cannot take your membership interest, they cannot run your business, and they cannot force a sale. But a single-member LLC in Florida is completely different. When you are the only member, Florida courts have repeatedly ruled that a creditor can go further. Courts have allowed creditors to foreclose on single-member LLC membership interest entirely. And that means a judge can order that your creditor effectively becomes the new owner of your LLC, your business, your assets, all gone. Now stop for a second and let that sink in. You built your company. You own rental properties, equipment, accounts, contracts, all inside your LLC. And because you formed it as a single-member entity without the right structure around it, a personal judgment creditor can walk in and take it. Now, the reason this happens traces back to a landmark Florida case called Olmstead versus FTC, decided by the Florida Supreme Court back in 2010. In that case, the court held that a creditor of a single-member LLC's sole member could be ordered to surrender his full membership interest to satisfy a judgment. It was a seismic decision, and it exposed every single-member LLC owner in Florida to a level of risk most of them had never anticipated. The Florida legislature responded in 2011 with amendments to the Florida LLC Act, but those amendments have limits. The charging order protection for multi-member LLCs was reinforced. For single-member LLCs, the vulnerability remains. Florida courts continue to treat single-member LLCs as having weaker protection because there are no members whose interest might be harmed by a creditor's interference. The law is looking at this form from the outside in. When there is only one member, courts ask, why should this creditor be blocked from full remedies? There's nobody else to protect, so they often aren't blocked. Now, here's where I want you to lean in, because most people hear this and they think, okay, I just need to add a partner. But actually, that's only one piece of the solution. And if you do it wrong, you can make your situation worse. Let me walk you through it with the right approach. Hey, quick pause here. If you're finding this information valuable, go ahead and hit that like button. It helps this video reach more business leaders who could use this content right now. And if you're not subscribed yet, subscribe now so you don't miss the next update on Florida business law. So here is what I call the Florida protection stack. It is a layered approach to LLC structuring that gives you real court-tested asset protection in Florida, not just the illusion of it. The first layer is converting to or creating a multi-member LLC. By adding a second legitimate member, and I want to emphasize the word legitimate because courts look for sham transactions, you immediately change the legal landscape. Florida's charging order protection is much stronger for multi-member LLCs. A personal creditor is now limited to a charging order. They cannot foreclose on your interest and they cannot invade the business. Now that second member can be a spouse, a business partner, a family trust, or in some cases, a separate business entity that holds a small percentage interest. The key is that the membership must be real, documented properly, and reflected in a carefully drafted operating agreement. Which brings me to layer 2 of the Florida protection stack, the operating agreement. Most people who form an LLC online get a template operating agreement that offers essentially no protection language. The right operating agreement includes what I call the fortress clauses, provisions that restrict the transfer of ownership interest, require unanimous consent for distributions, and specifically limit the remedies available to charging order creditors. When these provisions are in place, a creditor who does get a charging order finds themselves holding an interest that generates no income and has no control rights. That creditor almost always settles or walks away. Layer 3 is proper capitalization and separation. And here's where so many business owners destroy their own protection without even realizing it. When you mix personal and business funds, when you pay personal bills from the business account, and when you don't keep proper records, you are handing a creditor the weapon they need to pierce the corporate veil. And piercing the corporate veil is the legal doctrine that allows a court to completely ignore your LLC structure and hold you personally liable for business debts. Florida courts apply this when they find that the LLC was not truly operated as a separate entity. And the reason piercing the corporate veil is so devastating is that it undoes everything else. You can have the best multi-member structure, the strongest operating agreement, and the most carefully drafted fortress clauses, and none of it matters if a judge decides your LLC was just your alter ego. So capitalization means having a real business bank account, maintaining separate books, documenting loans and contributions, holding required meetings, and keeping minutes. This is not optional. This is the foundation. Now, for those of you who are holding significant assets, multiple properties, business lines, large investments accounts, there's a fourth layer I want to mention, the Florida Series LLC. Florida adopted the Series LLC framework, and when used correctly, a Series LLC allows you to create separate protected cells within a single LLC umbrella. Each series can hold different assets, and the debts and liabilities of one series are generally insulated from the assets of another. It's not a perfect tool, the law is still developing, but for real estate investors especially, a properly structured Series LLC adds a meaningful layer of separation. And sitting above all of this for maximum protection is an irrevocable trust or a domestic asset protection structure. When you place your LLC interests inside the right trust structure, you can further insulate those assets from personal creditors. The key word is irrevocable. Revocable trusts provide essentially zero asset protection in Florida. The reason is that if you can take the asset back, so can your creditors. But here's the thing, and this is something most YouTube videos won't tell you. Timing matters enormously. You cannot transfer assets into a trust or restructure your LLC after a lawsuit has been filed or a judgment entered against you. Doing so is called a fraudulent transfer, and Florida courts will unwind it. The Florida Uniform Fraudulent Transfer Act is not a technicality. It is aggressively enforced. And the only time asset protection planning works is before you need it. The time to fix your structure is right now when everything is fine. So let me bring this all together for you. If you are running a single-member Florida LLC right now, you are exposed. The charging order gap is real. The Florida courts have shown they will use it. And the fix is not complicated, but it needs to be done correctly and with the right documentation and the right legal structure. The Florida Protection Stack is your answer. Add a legitimate second member, draft a strong operating agreement with fortress clauses, and keep your entity properly capitalized and separated. Consider the Series LLC if you hold multiple assets. And if your exposure is significant, explore how an irrevocable trust fits in your structure. Do not wait until you're being sued to think about this. The moment a lawsuit is filed, your options narrow dramatically. The moment a judgment is entered, they narrow even further. The window to protect yourself is right now. If you have questions about your specific situation, reach out to my firm. A link to schedule a consultation is in the descriptions below. Every business is different, and the right structure for a solo real estate investor looks different from the right structure for a multi-location business owner. This video gives you the framework, but getting it right requires looking at your specific facts. And if this video saved you from making a very expensive mistake, and it may have just done exactly that, do me a favor, hit that like button and share this with any business owner you know who has a Florida LLC. You might save them something they can't afford to lose. And make sure you're subscribed so you never miss a video like this one. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.